Attorney General in February of this year. General Barr is a distinguished career civil servant and is no stranger to the role of Attorney General. He previously served as Attorney General under President George H.W. Bush from 91 to 1993. During this time, he helped create programs and strategies to reduce violent crime and establish new enforcement policies for financial institutions, civil rights, and antitrust merger guidelines. He led the department's response to the savings and loan crisis and oversaw the investigation of the Pan Am 103 bombing. Prior to his graduation from George Washington University Law School, he served in the CIA. He also worked in the White House under President Ronald Reagan as a domestic policy staffer. Before returning to the AG role, he worked for various corporations, advising them on government enforcement matters and regulatory litigation. It is an honor and a privilege for me to introduce and bring to the podium to close out our Capital Forum, Attorney General William Barr.
Thank you very much. Thank you very much. Good afternoon, and thank you, General Landry, for that kind introduction. And thank you to NAAG for inviting me to join you today. It's an honor and privilege to be with my fellow attorneys general. I am a two-time offender as the 77th and the 85th Attorney General. I was 41 years old the first time, and now I'm 69, almost 70. And the lesson I've learned is that, especially these days, you're only suited to be Attorney General, at least of the United States, if you're too young to understand the risks or too old to care. Through the executive working group and in various operations, we've been working together on several important law enforcement priorities. Elder justice is a personal priority for me, and I know the state AGs have been leading the charge for many years. Derek Schmidt's presidential initiative highlighted the impact of this important issue. Each year, over $3 billion are stolen from or defrauded from millions of our elders through a variety of malicious schemes. The state AGs are on the front line in this fight to prevent the elderly from being exploited in this way, and I pledge the department's full support in that effort. Another area, human trafficking, is an important law enforcement issue for both the department and for the state AGs. And I know General Paxton and Healy and Becerra and Reyes and many others have been leaders in this vital effort. And we work together to take down Backpage.com, and we continue to engage with our state partners through our Human Trafficking Protection Unit. And we look forward to continuing that work with you and to make more progress in this critical area. In addition to these important priorities, another topic that involves almost every AG in this room, and one that also benefits from the close federal-state cooperation, is the review into market-leading online platforms. In DC, it's hard to find many things that everyone agrees on. One thing that I found wide and bipartisan support in, however, is the government's taking a closer look at the leading online platforms and the competitiveness of digital markets. When I was going around trying to muster up votes during my confirmation process, some of the senators who otherwise opposed, this was the only thing that they were friendly about, my views on antitrust enforcement. Online platforms play an important role in our economy and in the daily life of Americans, often serving as gateways for how we access goods, services, information, and even each other. A few digital platforms in particular have enjoyed significant growth over the past decade, and consumers now depend on these platforms every day of their lives. Their size and their pervasiveness have led to public concern about the competitive health of these digital markets. We've heard widespread concerns from consumers, businesses, entrepreneurs, including about stagnated innovation, high prices, lack of choice, privacy, transparency, and public safety. And in response, DOJ initiated a review into market-leading online platforms, which we announced publicly last July. Concerns about these platforms have come from a wide variety of stakeholders across the political spectrum. Indeed, almost every state AG is now participating in publicly announced antitrust investigations of Google and Facebook. And I recently met with each of those working groups at the Department of Justice, and I think we have good cooperation and close coordination underway. Now, as you know, this is not the first time that the Department of Justice has cooperated with a bipartisan coalition of state AGs on an antitrust matter involving a digital platform. When the Department of Justice litigated a case against Microsoft roughly 20 years ago for antitrust violations, it was joined by a coalition of 20 state attorneys general and the District of Columbia. There are still those in the department and in the state AG community, including my friend Tom Miller, who were closely involved and remember it well. Today, the state AG coalitions investigating Google and Facebook are even bigger than in Microsoft, including almost every state and federal territory. I think this demonstrates the importance of these issues to the Americans across the country, regardless of location or political persuasion. Now, the benefits of a broad approach to online platforms goes beyond building a broad federal-state coalition. A broader holistic perspective is important as we consider the substantive issues raised by these digital companies and in the digital economy, issues both within and outside the arena of antitrust. Let me start with antitrust. Antitrust is a core focus of the department's review because ultimately fair competition can cure many of the ills we see. In a functioning free market, consumers can demand alternatives that better address their preferences, including for greater privacy, more transparency, or increased safety. For consumer choice and the free market to work, however, firms have to be playing by the established rules of competition, and that's where antitrust enforcement steps in. Many online platforms are not only big, but also offer a wide breadth of products and services. Antitrust enforcers, therefore, must take an equally broad view of these platforms' offerings and the relationship between different markets, products, and business practices. Let me touch on a few examples where a broader perspective is useful in antitrust analysis. First, a broader perspective requires understanding the characteristics of the market. This includes looking at whether there are high barriers to entry that prevent or deter new competitors. For example, digital platform markets are often characterized by economies of scale and scope, including direct and indirect network effects. Take, for example, direct network effects in social media. The more users on the same social media platform, the more valuable that platform is overall. There are benefits to consumers in being on the same network as their friends and family. At the same time, the existence of such network effects can make it harder for a new platform to attract users. This positive feedback loop is also inherent in platforms that rely on data and machine learning. For example, generally speaking, the more data a search engine has, the better its algorithms for search results can be. The better the algorithm, the more users it can attract, and with them comes even more data, and the cycle starts anew. Digital platforms can also have indirect network effects, meaning the more users on one side of the platform increases the value to users on the other side of the platform. In Microsoft, for example, there were indirect network effects that created what the court described as an applications barrier to entry. The more consumers that used the Microsoft operating system, the more attractive the platform was to the application developers. Conversely, the more applications that were used on Microsoft operating system, the more attractive the platform was for users. These indirect network effects created a barrier to entry that helped Microsoft's monopoly. Network effects are not inherently problematic. However, where strong network effects create a significant barrier to entry, it can lead to increased market power, which in turn can be used in anti-competitive ways. Given these dynamics, antitrust enforcers must be particularly vigilant to police for agreements and conduct that harm the competitive process. Similarly, market power is not itself wrongful. As I've said before, big is not necessarily bad. Healthy competition creates winners and losers, and the prospect of winning and the profits that come with it can drive innovation in the first place. Success that comes from creating a better, more innovative product should be applauded. The danger, however, is that as a monopolist, even one that earned that status lawfully, can be tempted to use its power to engage in anti-competitive conduct to preserve its dominant position. Moreover, the existence of market power can change the competitive effects of a business practice. Conduct that may be pro-competitive for a new entrant can become anti-competitive if undertaken by an incumbent 900-pound gorilla. For example, exclusivity agreements by a new entrant can increase competition by enabling a competitor to attract users with unique offerings, even in markets with a strong network effects. At the same time, exclusive dealing by a monopolist could have the opposite effect by depriving rivals of the necessary inputs or scale necessary to compete. Bundling, tying, predatory pricing, and certain refusals to deal are other examples of conduct that can become problematic when undertaken by a firm with market or monopoly power. As digital firms transition from being the disruptive new entrant into established market leaders, they should pay attention to the impact of their business practices, and so too should antitrust enforcers. Second, in addition to understanding the dynamics within a market, like barriers to entry and market power, we also need to look at the relationships between markets. This is especially important because today's digital platforms frequently operate across multiple areas. A dominant firm may seek to leverage its monopoly power in one market to gain unfair advantage in another. In the Microsoft case, for example, a key concern was that Microsoft was abusing its dominant position in operating systems to foreclose competition in browsers. The relationship between markets can be even more complex in the digital age, with the emergence of new business models and increasingly the importance of role of data. Law enforcers need to better understand how consumer data is collected, used, and shared within a firm and with third parties. Such antitrust inquiries generally require a broader perspective and a deeper understanding of how each of these markets function. Taking a broader perspective is particularly important in the context of free online services. Digital platforms are not charities, and when they offer services to consumers for free, that just means they are making money somewhere else, either through a different product, from a different consumer, or at a different point in time. The increasing prevalence of and complexity of free online digital services may require a broader and more intense investigation. First, antitrust enforcers may need to look beyond the free service to better understand a firm's monetization strategy and incentives. Enforcers also may need to look more closely at non-price effects. Fortunately, the long-standing consumer welfare standard enables us to analyze non-price effects on competition, including on quality, innovation, and consumer choice. A broader perspective also requires looking beyond antitrust. As we listen to complaints from the public, from industry, from experts, it's become clear that not every problem related to online platforms comes within the reach of antitrust laws. Some have therefore proposed expanding the antitrust laws to reach other non-economic harms. Drastically reinventing the antitrust laws, however, is neither easy nor advisable. The Sherman Act has been around for over a century and has proved flexible enough to adapt to a wide variety of industries, including digital platforms. We are open to considering new tools and targeted modifications, but a wholesale departure from the antitrust law's focus on competition is unwarranted. While we should not distort the antitrust laws, the Department of Justice also cannot ignore real harms to the American people. Where there are non-competition harms, DOJ will consider whether there are other tools, including other legal or policy frameworks, that can help. We are thinking critically about how DOJ and our state partners can address other topics related to online platforms, such as privacy, transparency, consumer fraud, child exploitation, or public safety. One example of a non-antitrust issue related to online platforms is Section 230 of the Communications Decency Act. Generally, Section 230 provides immunity to interactive computer services for third-party content on their platforms. As this group well knows, there is currently a robust public debate over Section 230. The NAAG sent a letter to Congress last May proposing an amendment that would carve out U.S., state, and territorial criminal law from the current scope of Section 230 immunity. And we too are studying Section 230 and its scope. The CDA was passed in 1996 in response to concerns about protecting children from sexually explicit content on the internet. It was enacted primarily for two purposes. First, the amendment sought to encourage platforms to self-regulate by granting immunity for blocking or filtering offensive material. In particular, the amendment aimed to overrule a 1995 state court decision that treated an online message board as a publisher of third-party content and thus liable for defamation because the service restricted access to some, but not other, objectionable material. Second, Congress sought to encourage the growth of online forums by immunizing platforms against liability for third-party speech. Section 230 was passed at a time where the Internet was relatively new, and Congress wanted to protect the growth of the online services and the ability of the Internet to offer a forum for true diversity of political discourse. Section 230 has been interpreted quite broadly by the courts today. Many are concerned that Section 230 immunity has been extended far beyond what Congress originally intended. Ironically, Section 230 has enabled platforms to absolve themselves completely of responsibility for policing their platforms, while blocking or removing third-party speech, including political speech, selectively and with impunity. Some also question whether such a broad immunity is still necessary to protect online companies. Indeed, 10 years ago, a Ninth Circuit opinion denying Section 230 immunity in part remarked, "The Internet is no longer a fragile new means of communication that could easily be smothered in its cradle by overzealous enforcement of the laws and regulations applicable to brick-and-mortar businesses." In other words, the opinion stated, the Internet has outgrown its swaddling clothes and no longer needs to be so gently coddled. The staggering breadth of Section 230 immunity as construed by the courts is evident in a recent Second Circuit opinion involving the Anti-Terrorism Act. There, the court held that Facebook was immune under Section 230 for allegedly matching and facilitating communications between members of the terrorist group Hamas. The court denied plaintiffs' argument that Facebook's algorithm and friend-matching service rendered it a non-publisher outside the scope of Section 230. Chief Judge Katzmann dissented in part, criticizing the virtually limitless scope of Section 230 that Section 230 immunity imposed. He argued that providing immunity for the steps Facebook took to connect alleged terrorists through algorithm and friend suggestions was far removed from the original purpose of the CDA to protect children against obscene material. He called for Congress to revisit the CDA to better calibrate the circumstances where such immunization is appropriate and inappropriate in light of congressional purposes. Chief Judge Katzmann is not alone in his calls for reform. Section 230 has garnered significant attention from experts, consumer groups, and legislatures. Within DOJ, we also have started thinking critically on this issue, and we want to engage further with experts, industry, and other government actors, including specifically NAAG, through informal discussions as well as a public workshop. As we look at Section 230, antitrust, and other issues raised by the online platforms, it is important to take a coordinated approach. The issues raised by online platforms are interrelated, and we sometimes must weigh competing interests in forming positions related to the digital economy. Privacy is a good example. For example, overbroad and overly burdensome privacy legislation could inhibit competition by entrenching monopolists with the resources to comply while thwarting newer entrants who do not have those resources. A single-minded focus on privacy above all other values also can impose significant costs, including cost to public safety. I have, for example, spoken before about the dangers of warrant-proof encryption. I won't repeat myself here, but would simply reiterate that technological innovation that purports to protect privacy at all costs while impeding sworn law enforcers' ability to go after violent criminals, child predators, human traffickers, and terrorists, even once they've satisfied the rigorous privacy protections built into the Fourth Amendment, may not be worth the trade-off. High-level coordination also helps avoid imposing conflicting obligations or inconsistent policy positions. This requires coordination both within and outside the Department of Justice. While we have some of the best and brightest at the department's antitrust division and across the department working on these issues, we benefit from the perspective and support of our state partners and our international partners. We also welcome consumers, businesses, experts, and others to talk and work with us to address the challenges of this digital age. The technology industry in America has brought great innovation to consumers in the U.S. and around the world. We must continue to encourage and incentivize innovation and economic growth. This means not unfairly punishing innovators that have earned their success on the merits, but it also means making sure markets are competitive and open to the next wave of technological change. As law enforcers, we also must keep up with technological advancements to best protect our citizens. This is why we have made the review of market-leading online platforms a top priority of the department. The state AG community plays a central role in this endeavor. And on behalf of DOJ, I thank all of you for your valuable partnership and look forward to our continued work together on this and many other initiatives. Thank you. Thank you. Thank you very much.